All right. Hi, welcome back, Attorney Steve Vondran. Today we are talking about post-trial motions. All right, so what happens? This recently just happened to the National Association of Realtors. They got hit with a $1.8 billion, B as in biscuit, billion dollar judgment in a case where they were basically said the real estate brokers and the National Association of Realtors were engaged in some sort of commission fixing scheme that costs homeowners money and this, that, and the other. They got hit with $1.8 billion. So they are filing one of these motions, post-trial motions. They are seeking remittitur. And so what's the difference between an additur and remittitur? So these are some legal terms to know, especially you law students out there getting ready for the bar exam. What happens if there's a giant verdict? Or what if the verdict is too low? There are some things you can do. Let's take a look. Number one, additur. This is a plaintiff's contention that the jury verdict was too low. What do you mean it was only $1.8 billion? It should have been $20 billion. So a plaintiff can file a motion for additur. Now, the defendant, like in this case, the National Association, would be saying just the opposite. I want to file a motion for remittitur, that the jury verdict was too high. $1.8 billion, are you crazy? This should be more like nothing or 200,000 or something. And plaintiffs should remit part of their award. So that's kind of what this is. So this is basically done as a mechanism of judicial economy or judicial efficiency. If the judge can fix something that may be clearly wrong, this can avoid having to grant a new trial and using more resources of another court just to hear this issue of the adequacy of the judgment. In additur, you're asking the judge to increase the award to what a fair and impartial jury would have awarded. Now, that leaves open a lot of things. And a lot of people say, well, what the heck? I mean, the jury sat there, they listened to the evidence, and they came up with $1.8 billion. What's the problem? Well, you know, a judge is sort of the last resort. A judge can actually set aside a verdict with a judgment notwithstanding a verdict, and can also grant an additur motion. And the judge could say, look, if it is the plaintiff's burden in an additur motion to show that there was some kind of error. They must prove some kind of prejudice or bias, some sort of discrimination, corruption, mistake of the jury. Something went wrong, like they misunderstood the jury instructions, or they were inflamed by passion or prejudice, or that the award was inconsistent with the evidence provided at trial. So this is, whoever's bringing the motion has the burden of proof. You need to prove it. You can't just argue, it was too high, too low. Come on, judge. This is crazy, judge. Do me a favor here. Come on. So you have to have some evidence, okay? So you have to have something to back your motion and see if you can get it granted. So that's really the difference. The remittitur is asking the judge to decrease a grossly excessive award, and again, showing that the verdict was tainted, something was definitely wrong, the evidence was not followed, this, that, and the other. Okay, so now this is basically a creature of state law. So check your states. You probably have an additur and a remittitur process for your state law cases. But what happens if you're in federal court? In federal court, there is no additur or remittitur. What it is, we look at Rule 59. So say you have a federal case like copyright law or Federal Trade Secrets Act, something like that, federal trademark case. A Rule 59 motion is to alter or amend the judgment. So they don't quite use that term, additur, remittitur, but again, this can avoid having to go through a whole new trial or an appeal. It's because the case can go up on appeal, and the judge can make the acceptance of a new award, either upper or lower, conditional on waiving your appeal rights. They say, well, this is what it's going to be. If you agree, let's waive any rights, and then let's enter this into the record. So again, this is for the purposes of judicial economy. If you can fix something easily without having to go through more time, more litigation, more resources. Here's a couple other things. Look at the intervening change of law. Maybe a new case came down after the verdict that shows you were actually right, or the defendant was actually right, or the plaintiff was right. look for intervening changes of law or new evidence that was not previously available. So say something popped up 2 weeks after the trial closed. You say, wait a second, halt the press, judge, halt the press. There's something new here. This verdict shocks the judicial conscience, as we call it, shocks the judicial conscience. Use of false evidence is another potential grounds. The verdict is not consistent with the evidence. So there's a lot of different ways to go about it, things you're going to need to show or prove as the moving party bringing the motion. But I just wanted you to have a basic understanding of these critical terms. We'll see what happens with the National Association of Realtors. Will the judge grant a remittitur to lower the $1.8 billion award? We'll see. We'll see what the National Association of Realtors argues and what kind of evidence they produce. All right. So there you go. Tip of the day: Additur versus Remittitur. Legalese made easy. Von Deasy, law made easy. So there you have it. If you need help with civil litigation, you know where to find me on the web at vondranlegal.com. Civil litigation. We also handle cases in California, business, real estate, intellectual property cases. Have a great day. General legal information only and not legal advice. We'll see you again soon. Bye now.